Ladies and gentlemen, good afternoon. A heartfelt welcome to this session on the Hague Conference on Private International Law. I would at the outset first like to thank the organizers of this wonderful event to have given us the opportunity to have a session on the Hague Conference on Private International Law and to just introduce this organization which is building bridges for global citizenship so that you have a better understanding of who we are and what we do. We do this with all the more a pleasure introducing the organization to you as we realize that when we address a specific category of professionals, they typically know very well what we are doing in their particular field, but they hardly have an idea as to what we do in other fields. So for example, when we talk to experts in the field of child protection and family law, they know very well some of our conventions, but they have no idea that we do commercial law or finance law or civil litigation law. And when we talk to notaries, they know everything about the Apostille Convention, but then they look at us and say, what, you're doing child protection law? I didn't know that. So we thought it was all the more relevant to give you a little overview of who we are and what we do. Then there is this first question that we very often get: why are you actually called HCCH? What does that stand for? Well, the secret is that we have two official languages, English and French. And so the name in English is the Hague Conference on Private International Law. In French, c'est la Conférence de droit international privé. Now, if you take the relevant letters of Hague Conference, Conférence de Haye, here is your HCCH. So that's the first mystery solved for you today. If you keep in mind one thing after this little presentation, it may well be this, but I hope there will be other things you will remember at the end of this session. What is the Hague Conference? The Hague Conference obviously is an intergovernmental organization. We are our own organization. We are not linked to the United Nations. We have cooperation agreements with some of the other organizations, but we are our own intergovernmental organization. The origin of which goes back to 1893. So we have been around for quite some time. The founding figure behind the Hague Conference was Tobias Asser, a Dutch statesman who had this great idea in 1893 to bring representatives of 13 European states together to discuss these private international law matters. But Tobias Asser was not alone. He actually had the very active and important support of Russia through the support that was given by Tsar Nicholas II, who sent his advisor Theodor Martens to The Hague, and Theodor Martens actively supported the choice of The Hague as the first venue of this Hague Conference on Private International Law. So I was very happy and touched actually to see the other day at the University of St. Petersburg the sculpture, the bust of Theodor Martens as one of the supporting fathers of the Hague Conference on Private International Law. I was told by the Dean of the Law Faculty that Theodor Martens was almost kicked out of the university because he spent so much time doing other things than lecturing, including helping put together the Hague Conference on Private International Law. I was glad to hear that they actually kept him. We are not only the oldest of all the intergovernmental organizations, or indeed international organizations based in The Hague, we are also the only one with a legislative function. We only do the law. We do not speak the law. We are not a court. We are not a tribunal. You cannot come to the Hague Conference and complain about a cross-border contract that has not been enforced, or you know, that something went wrong in your cross-border situation. We only, quote unquote, develop the rules that apply in cross-border situations, but we have no judicial function whatsoever. We do monitor the operation of our conventions. I will talk about this in a moment, but we have no policing function, and we don't have, certainly not, a judicial function. The Hague Conference kept its name even when it became a permanent organization in the early 50s. After the Second World War, the Dutch government had actually decided to resume the activities of the Hague Conference, but to give it a permanent structure, and that's why the first statute was adopted around this time, which was then later on revised. That explains the funny name of the Hague Conference. You certainly wonder, why is it called the Hague Conference? Well, at the beginning, it was a series of conferences, and in between two conferences, nothing would happen. The experts would come to The Hague, discuss their topic, then go back home and meet again the following year, and so on and so forth. It's only after the Second World War that the Dutch decided that it should become a permanent organization, which prompted them to establish the Secretariat. And instead of calling it the Secretariat, they called it the Permanent Bureau. So we work at the Permanent Bureau of the Hague Conference on Private International Law. It's a bit of a funny terminology, but once you understand it, it's fine. So what then is the Hague Conference on Private International Law? Well, the mandate, according to Article 1 of our statute, is to work for the progressive unification of the rules of private international law. We only do private international law. First of all, we don't do criminal law, we don't do public law, and we only do private international law. That is, to deal with situations that have connections to more than one state. That can be a cross-border family situation, a Russian wife and a Canadian husband. It can be a machine that's produced in Germany and delivered to Russia. It can be as simple as a public school diploma from St. Petersburg University that needs to be produced in Switzerland. These are cross-border situations in which you want to know what law applies, which court has jurisdiction, what about the recognition and enforcement of foreign judgments, and so on and so forth. What we do, therefore, is to provide these road signs, these traffic signals, which in cross-border situations tell you where to go, which court has jurisdiction, which law applies, what you can do to have your judgment recognized and enforced. But our rules do not give you the substantive answer to the issue at stake. For example, if a new machine has to be delivered or if the full price has to be paid. These are questions obviously left to the substantive law of the relevant jurisdiction. We simply provide these road signals. And that's precisely what I personally like about private international law, because it builds these bridges among different legal systems, but it does so while preserving the legal diversity, the cultural diversity that is reflected in each domestic legal system. So we don't harmonize substantive law. How do we do it? We do it by developing these famous conventions, the Hague Conventions. There is a total of 38 conventions on the books. You may have heard of one or two of them, but there are actually 38 in total. Granted, not all of them are equally important. We like to say that there is about 10 to 12, maybe 15 sort of core important core conventions that very often set international standards and which as a result have been widely ratified around the world. But if you are a new state looking at the Hague Conference, don't be afraid that you would have to sign up to all these 38 conventions. That's not the case. We're talking about roughly a dozen conventions at the time being, which are really significant and important. The beauty of these instruments is also that they coexist with regional or other bilateral treaties to which your state might be a party. So there is typically a clause at the end of these Hague Conventions that say, you know what, if you are party to another treaty and that treaty is also applicable in the current situation, we, Hague Convention, we do not impose ourselves over these other treaties, and if this other treaty provides a solution that is better suited for your particular situation, then please continue to do so. But our treaties, of course, do so at the global level. That's the beauty of the conventions. You have one single system of road signs and traffic signals that is the same across the board. So each of these 38 conventions typically deals with one or more, sometimes all, of the following core private international law questions. I've already alluded to it. In a cross-border situation, you want to know which court has jurisdiction to hear the case. If there is litigation arising out of your, for example, contractual relationship, or you have a cross-border tort situation, which law applies to this relationship? What can you do to have your judgment recognized and enforced in another jurisdiction? And very importantly also, most of these successful conventions establish a system of cooperation among states, where each state is mandated by the convention to establish an authority, a central authority typically, that cooperates with other authorities in the other state to overcome the challenges raised by the cross-border nature of the situation. The conventions can be categorized in three different pillars, really, the important core conventions. There is the first important pillar of child protection, family, and property relations. Here we have, importantly, the Child Abduction Convention, which some of you may have heard. This convention deals with a situation where you have typically a breakup in a couple's relationship. One of the partners or former spouses takes the child to his or her state of origin, typically in violation of a custody right of the other parent. The idea of this convention is to ensure that the child is being sent back as quickly as possible to his or her state of habitual residence for the authorities in that jurisdiction to take all the appropriate measures. Very important convention, actively supported by organizations like UNICEF. UNICEF does recommend the ratification of this convention. The Committee of the Rights of the Child within the UN recommends the ratification of this convention. Truly an important convention. 92 contracting states. The Inter-Country Adoption Convention, which really sets a framework so that cross-border adoptions of children only take place in the best interest of the child, with all the safety measures in place. And typically, there's a matching decision between the state of origin of the child and the receiving state of the adopting parents to make sure that this is the right child for the right parents. 93 contracting states around the world. Again, a convention that is actively supported by relevant other organizations. We have the 1996 Child Protection Convention with currently 40 contracting states and growing, which in many respects complements the Child Abduction Convention by providing a system of jurisdiction, applicable law, recognition and enforcement of measures taken towards the protection of a child in a vulnerable situation, and which also establishes a system of cooperation among states. And then there is the fairly new Child Support Convention, which establishes a system to facilitate the effective recovery of child maintenance and other forms of family maintenance in another state. This clearly is the next big thing for the Hague Conference in terms of family law. Practically speaking, a very important convention. That is the first pillar, family law, child protection law. But then we have a second pillar of legal cooperation and litigation. Here we have first the so-called apostille convention. You may wonder, what is an apostille? An apostille is an old French name for a certificate that authenticates the origin of something. So this convention essentially says when you have a public document, be it a notarial act, a judgment, a patent, an extract of a register, a public school diploma, what have you, if that has been executed in one state and needs to be produced in another state, typically there is a system of legalization that takes place. This apostille convention does aside with all of this bureaucracy and red tape and facilitates the effective production of documents abroad. 107 contracting states from around the world. It's the most widely ratified of all the conventions, used millions and millions of times a year. The World Bank, the ICC in Paris, the International Chamber of Commerce, actively recommend ratification of this convention or accession to this convention because it facilitates cross-border trade, because it facilitates cross-border investment. Service convention. This is a convention that facilitates the service of process into another state. So imagine you have legal proceedings that have started here in St. Petersburg, your defendant is, say, in the Netherlands. How do you ensure that the defendant receives the summons and is being informed of the proceedings that are ongoing in Russia? Typically, without convention in place, you have to go through the diplomatic channels, which is long, which is cumbersome, which is slow, not efficient. With the service convention, you have a much more direct system in place. 68 contracting states. Same for the evidence convention, how to take evidence in another state, in civil and commercial matters. System in place that provides for the easy taking of evidence in other jurisdictions. 58 contracting states. Access to justice, which essentially is a non-discriminatory instrument so that people or nationals from or people habitually resident in one contracting state have access to justice under the same circumstances as nationals or people habitually residents in another contracting state of the convention. And importantly, the choice of court convention, which is a new convention, which essentially says that if two parties to a B2B contract, a business-to-business commercial contract, say any litigation arising out of this contract shall be heard by the courts of St. Petersburg, say, the effect of that convention is to say only the courts in St. Petersburg have jurisdiction to hear the case. No other court in another contracting state is entitled to hear the case, and the resulting judgment is to be recognized and enforced. We had, just prior to this forum, a side event about this convention and other ongoing work at the Hague Conference to explain and promote this instrument, which is likely to see its number of contracting states increase in the near future because the European Union is about to approve this convention, and it will then be in force in all the members of the European Union. The United States is actively preparing ratification. There are other states that will put this system into place. So that essentially, if you are operating in a commercial context, you have an alternative to arbitration. An alternative to arbitration, because for arbitration, of course, you have the very successful 1958 New York Convention, which facilitates the circulation of arbitral awards. But arbitration is certainly very professional, very diligent, can be speedy, but it also is very often quite expensive. And for small and mid-sized companies, arbitration, therefore, is not always a real option. And they would be happy to have the litigating alternative at their disposal, But for that, they need legal certainty and predictability, so that when they say, we actually want to have our litigation heard by the courts in St. Petersburg, that you really end up here in St. Petersburg and not somewhere else in another jurisdiction where possibly you get far higher damages or what have you in a legal system that is unfamiliar to you. Then the commercial and finance pillar, if it comes up. Here it is, we have a trust convention that essentially recognizes the establishment of a trust in one jurisdiction, recognizes its effects in another jurisdiction, and there is a new securities convention that deals with intermediated securities. Nowadays, when you transfer securities, you don't get to have the paper certificate anymore. All of this is done in electronic form by electronic book entries. That raises all sorts of highly interesting private international law questions. This convention deals with that. So this is, in a nutshell, really, an overview of the three pillars of the most important conventions that have been developed by the Hague Conference on Private International Law. What about the presence of the Hague Conference around the world? Well, we first have our headquarters, if I may say so, in The Hague. This is the permanent bureau. From there, we serve the world, yes. But sometimes we feel uncomfortable when we come from The Hague and we go to specific regions of the world and we don't have a specific knowledge about the legal reality in this part of the world, the legal culture, indeed the legal systems. That's why our members have decided that we should move closer to some specific regions. And that started in 2005 when we first opened a regional office in Buenos Aires to cover Latin America, if I may say so. And then more recently, December 2012, we opened another regional office in Hong Kong to cover Asia Pacific. Looking at this map, you can easily imagine where we think other regional offices should be opened. Africa is a priority, and who knows, maybe other parts of this part of the world as well. Stay tuned. Now, you will certainly wonder, well, he has been talking about the Hague Conference for so long now. What are actually the members of this organization? Well, here you have a map of the membership of the Hague Conference. All states in dark blue are members of the organization. I have a few paper copies here of that map for you to take away afterwards. This is a total of 76 members. That is 75 member states plus the European Union as such. So the European Union in itself is a member of the organization in addition to its 28 member states. Then you have a few other colored states. These four states, Colombia, Lebanon, Azerbaijan, and Armenia, have been admitted as a new member by vote. They have gone through the 6-month voting period. They simply need to accept our statute, and then they will be a member of the organization. And recently, Tunisia requested to become a member of the organization and is undergoing the 6-month voting period right now. Every single state has happily been accepted by the Hague Conference so far. So this voting process really is a mere formality. When I look at this map, if I can come back, well, I'll tell it afterwards. This diagram shows the impressive growth of the membership, in particular since the late 90s, early 2000, which really tells us one story. We are obviously in a globalized world. The questions of private international law are questions that we feel and face regularly. the work, the mandate, therefore, of the Hague Conference is very, very important, and more states are turning to the Hague Conference because they realize they need the answers that are provided by our conventions. Now, I said 76 members, but there is actually a big but. And the but is reflected in the next slide. There is a total of 144 states that are actually connected with the work of the Hague Conference. How come, you will ask? Well, the answer is simply that a state does not have to be a member of the organization to join one of our conventions. So states can get a free ride, if you want. They don't contribute to the budget, and yet they benefit from the legal certainty and predictability, from the legal cooperation mechanisms that are put in place by our conventions. Now, if you put all the states together, the members and the non-members that are party to at least one of our conventions, you get 144 connected states. Now, based on this map, I feel comfortable to say that the Hague Conference truly is a global organization. Based on the membership map, not so much, because as we saw, there is still a lot of work to be done in Africa and some parts of Asia Pacific. When it comes to the connected states, the situation is already a bit better, although, and I'm happy to have some states here represented that are not yet connected from Africa or from Asia Pacific. Our hope really is to see this map being colored more and more in the years to come. One of the things that is important to keep in mind when we talk about some of our work and some of our conventions is that this really gives effect to human rights. Let me give you an example. You have, for example, the UN Convention on the Rights of the Child of 1989, ratified by almost all states, but 3, I think it is now. This convention establishes a series of important but fairly general principles. For example, that a child has a right to have regular contacts with both its parents, that children should not be displaced, that states should fight trafficking, and what have you. These are all very noble, very important, fundamental principles. But there is no implementation mechanism that comes with this convention. It is by becoming a party to our relevant conventions that deal with these questions, such as child abduction, adoption, or effective child support, that a state actually implements these principles that are established by the UN Convention on the Rights of the Child. Very important to keep in mind. On the other side, our conventions also often have an intersection, have a link with cross-border trade and foreign direct investment. Take something as mundane as the Apostille Convention, which facilitates the production of public documents, as I explained before. The World Bank ranks the attractiveness of a jurisdiction for foreign direct investment by also taking into account whether or not that state is a party to the Apostille Convention. In essence, if a state is party to the Apostille Convention, it gets 1 point more in the ranking of the World Bank, because that convention cuts formalities, the red tape, simplifies things, therefore facilitates cross-border trade and foreign direct investment. Same goes for the ICC in Paris, the International Chamber of Commerce. The Choice of Court Convention, exactly the same story, because it does provide for this legal certainty and predictability of your litigation system in place. There are organizations such as the ICC and others which again actively support the convention because it's seen as facilitating commerce, it's seen as facilitating trade. And for the Securities Convention, this more finance law-oriented convention, again, by becoming a party to this convention, you actually facilitate the flow of capital and access to international capital, because in particular, the rules applicable to collateral and perfection of pledges are much clearer with this convention. So there is always the bigger picture, the relationship with human rights and commerce and trade that is also very relevant for our conventions. So far, I have only talked about actual conventions, that is, hard law. But more recently, the Hague Conference has also embarked on a slightly different path, where instead of developing hard law in form of conventions, we have started to work on soft law by developing, in particular, so-called Hague principles on choice of law in international commercial contracts. This is a series of 12 principles to promote the idea of party autonomy in commercial contracts. The idea is to promote party autonomy, but within a comprehensive system and framework, so that there is no abuse of party autonomy in this context. That's the first soft law instrument that we have applied or that we have developed with the Hague Conference, and we are about to finish this work. Then, what about us, the Permanent Bureau? What do we do day in, day out? First of all, I wanted to show you a picture just that you get an idea of the size of the organization. We are not the United Nations. We are not the European Union. We are not this big organization with hundreds and hundreds of people working there. You have seen that we have 38 conventions and we look after them. There is a total of not even 30 people doing the work that we do in this little office. This, by the way, is a picture which we will soon have to change, because we are about to move offices to a slightly bigger place, that's true. But what we do basically is, if I can come back, is do the normal secretarial work of an intergovernmental organization, that is to liaise with all our members and what have you. But more importantly, we prepare the negotiations of a new convention by doing the basic research, by taking an active part in the negotiations, by sometimes suggesting solutions. And in particular, we are heavily involved in post-convention services. We firmly believe that it is one thing to put all these conventions on the table, and it's another thing to make sure that they really work in practice. So post-convention services are very important. The challenge, of course, is to find the balance, the right balance between developing new instruments and looking after the existing ones for an effective use of our scarce resources. What are these post-convention services? Well, obviously, promotion. We promote our conventions because very often they are not known by the wider audience. We go to places, we start to talk about these issues, and very often the response is, that's actually quite interesting. We face exactly these issues. These are exactly problems we need to solve. We just had no idea that there is this organization out there that provides the solutions. So promotion is important, and we are also helping where we can and subject to available resources with the implementation of these instruments. Sometimes states that are not so familiar with private international law or our work in general, they need help for the sound implementation and then operation of the conventions. And to the best of our possibilities, we try to accompany states in this process, which is something that we can offer with a degree of priority to member states as opposed to non-member states. This is actually one of the, practically speaking, most significant advantages. Becoming a member of the organization gives you priority access to technical assistance. Then, financial aspects, we have to mention them. Each member state plus the European Union, they contribute to the budget of the organization. The budget of the organization is fairly modest, 3.7 million euro for all the work that we do. Most of the times it's actually very surprising to the states in particular when they hear about this figure. Again, we are not the United Nations, we are not the European Union, and every single cent that's invested in the organization is typically a cent very well spent. We follow the system of the Universal Postal Union when it comes to determine the contribution of a member. I'm not going to go into details. Suffice to say that smaller states, states with a lower GDP, pay less than larger states, economically stronger states. Makes a lot of sense. So there's a system of units, and the units go from 1 to, in our system, 25 units. The biggest payers are Canada, France, Germany, Japan, the UK, and the US. They all pay 33 times 6,000 euro as a contribution to our budget. The Russian Federation, by the way, pays 15 units, so 15 times 6,000. I'll let you do the math. Here you have the contributions of the states to our budget. Finally, what do we have in the pipeline? What are we working on? What can you expect to hear from the Hague Conference in not so distant a future? We are, as I said, close to finalizing the Choice of Law and International Contracts project, these 12 principles that I referred to. Then we are firmly engaged in what we refer to as the Judgments project, which will hopefully lead to a convention on the recognition and enforcement of judgments in civil and commercial matters. It's actually quite surprising that in today's world, we still don't have a convention out there that facilitates the recognition and enforcement of judgments in civil and commercial matters. There is no judicial equivalent for the recognition and enforcement, broadly speaking, to something like the New York Arbitration Convention. That's something that we are actively engaged on, and we'll see if we'll also add something on direct grounds of jurisdiction to establish criteria when a court is competent to hear a litigation in civil and commercial matters. Then, slightly less advanced, because the Council on General Affairs and Policy, which is the highest organ of the organization, still has to take a final decision on these things. There is a project on parentage and surrogacy. So essentially, that is the possibility of developing a convention, I would have thought, that will essentially protect the rights of children born out of surrogate arrangements. One may think whatever we want about these alternative forms of procreation. Fact is that children are born out of these situations, and their legal situation is all but clear. This convention could help answering some of the crucial questions that are waiting for an answer. Then we are also exploring the possibility of doing something in the field of the recognition and enforcement of voluntary agreements, in particular mediated agreements in the field of international child disputes. Again, here the situation or the challenge is that typically you have a package deal situation where parents mediate on a number of questions, such as the custody of the child, access rights, visitation rights, maybe some financial aspects, such as maintenance obligations, and there may be some other measures they want to take with respect to the education of a child. These mediated agreements, if they have a cross-border element, need to be rendered binding in the other jurisdiction as well. That is sometimes subject to challenges, but we are exploring what these challenges really are in practice and to what extent the existing instruments do not cover the matter. And then the recognition and enforcement of foreign civil protection orders, the protection order issued in one state to be recognized in another state. Again, we are exploring this as a possible topic for further work. This is really, in a nutshell, what I wanted to share with you. I think that is actually what was all in the presentation. So you see, I think, a small but fairly active organization that keeps growing, that keeps attracting new members. More and more states become aware of the relevance of this work. More and more states are joining these conventions. I would like to take this opportunity to invite all those who represent here states that are not yet connected with our work to start looking into it and to explore this exciting, important, and very relevant work of the Hague Conference on Private International Law. I will be here for a while to answer any questions you may have. I have also in the audience two of my colleagues over there, Marta Perdegas and Cara North, who will also be ready to answer any questions you may have. In the meantime, I thank you very much for your attention. Thank you. Yeah. And then if you want to take some of these maps with you, or what is actually the status chart of our conventions, I'll be happy to hand you a copy on your way out. Thank you very much.